Welcome, everyone. Great to see you all here. Welcome to this panel on some legal considerations that you can take into account when preparing for the hackathon. After this panel, we'll have another panel which will take you through some legal considerations to take into account after the hackathon. My name is Lucassen. I'm a lawyer at Loyens Loeff, and I specialize in data protection, privacy, and life science. And I have three of my colleagues here. Would you like to start introducing yourself, Jonathan?
Yes, thank you very much, Kim. Good afternoon, everyone. My name is Jonathan Ruff. I work as an attorney at Loyens Loeff, and I specialize in international law.
Hello, everyone. My name is Yannick Geryszewski. I'm also an attorney at Loyens Loeff, and I specialize in software and intellectual property.
My name is Nina Orlic. I also work at Loyens Loeff as a lawyer, and I specialize in data protection and privacy law.
It will now be our third year as a legal partner at the hackathon, and people that have been involved know us as Legal Jedis. And we wanted to share today with you some of our experience, the questions and the issues that we've seen during the hackathon. We'll not dive into the specific challenges, because all of them have very their own legal considerations, like energy, healthcare, life science. But we'll try to keep it high level so that everyone can benefit from what we're saying. Yannick and Nina have been involved in the previous hackathon. Yannick, do you want to share some of your experience and the things that the questions that you've got?
Sure. Well, not surprisingly, nobody read the general terms and conditions of the hackathon last year. I think nowadays, or this year, won't be very different in that respect. There are a few bits of important information in the general terms and conditions. The first being that all intellectual property that is created by an individual team member is automatically owned by the entire team. There are two exceptions to this rule. The first being if the entire team agrees otherwise, so you can make different arrangements with the entire team. And the second being if the law says otherwise. For example, if you participate in the hackathon and you have a really cool job participating in the hackathons, your employer would normally be the one that owns the intellectual property that you create during the hackathon.
Is there anyone who has such a great job participating in a hackathon? Yeah? Okay.
Lucky you. The second thing to note is that general terms and conditions also say something about open source software. The first being that your solution, the team must own or validly license all intellectual property rights in the solution that you provide to the hackathon. So you need to check if you use open source software, whether the license allows you to use that software for the solution in the hackathon. Another thing is that most teams need to choose an open source license under which they publish their solution on GitHub.
So Jonathan, for you it will be the first time as a legal Jedi this year. So from your expertise, is there anything that you think you will encounter as an issue or a question?
Yes, two things pop up. The first one, I do think that a number of the challenges this year will have a cross-border nature, so that in itself could automatically involve some international law elements. And the other point being that I do think that artificial intelligence techniques will be applied in some of the challenges, and that may raise ethical/human rights issues. But we will talk about that later.
How about you, Nina? What did you encounter?
I think from a data protection perspective, the biggest misconception that a team would have is stating that they will not use any personal data. Because I'm sure many of you are aware that under data protection laws, and the GDPR in particular, the definition of personal data is very broad and includes all information which is not only directly can be traced to an identifiable natural person, but also indirectly. So even if you encrypt certain data, it might not be enough to use it as anonymous or non-personal data. So that is something which I think is really important to keep in mind while you're working on any solution.
So if that's the case, if personal data is involved, which I understand is often the case, what would that mean? What would it trigger if GDPR would apply?
So basically, if the solution is offer services or goods to consumers within the European Union, or the party using such software would be in the European Union, GDPR would indeed be triggered, and that would basically mean that you'd have to really consider what you're doing and how you're doing it, because the GDPR starts from certain principles, which actually force the parties working with data to consider how they use it and be accountable for how they're using it. So for instance, you cannot collect data and figure out what you do with it along the way. You really have to determine beforehand for what purposes you will be using it, how long you need it. You need to ensure that you have a legal ground to collect such data. So there's really a lot of things that need to be taken into consideration. And of course, there's these subject rights that you need to comply with. So people might want to have information about their data or access their data. And that's all elements that you need to be aware of when you're making something.
Yannick, you just mentioned something about open source license. So what is important to think about when choosing?
Well, in general, there are two flavors of open source licenses. You have the so-called permissive open source license, which basically means that you can use the software for anything you want, as long as you name the creator in any new piece of software you create. Then you also have the copyleft license, which is more strict. Copyleft license basically means that if you create new software in which you use the open source software, being if you copy a piece of software or if you amend the open source software and then incorporate it in the new piece of software, that the original open source copyleft license also has to apply to the new piece of software. And that is something you need to take into account, because in the end you need to make sure that you apply an open source license to your solution. And if you use open source copyleft licenses or software to which those licenses apply, and you then choose a permissive license for your entire solution, that might not be compatible. So that is really something you need to take into account when using open source software and when choosing a license.
So who read the terms and conditions? No one? Okay. So is there any specific questions on this? Because I think it's quite important to think about this. Does anyone have a question to Yannick about this?
Maybe some common examples of either the two license types?
Yeah, a common example of a permissive license would be the so-called MIT license, which is indeed from the university MIT. And we have the so-called GNU license, GNU, which is the copyleft license. But to be fair, there are over 200 open source licenses, and it is also possible to deviate from those licenses. So under Dutch law, you can, for example, take a copyleft license and then amend it slightly to make sure it fits your business case and it fits your solution. So one thing to note is take a well-known open source license, since it furthers adoption. If people know what they can expect, they will comply more with your license and they will know what to expect. But it is possible to tailor it to your solution as well.
Okay.
Regarding the team owns the API of the product, the intellectual property of the product, of the future solution. Actually, you mentioned that if a team, for example, doesn't want to own the API, if the team doesn't want to own the intellectual property rights for the product, maybe like only one individual has to own the product, the API IP of the product. How should we, for example, sign the kind of document that if only I want to have the intellectual property rights for this product? we have to sign the document via notary, or how we should define who would own the product?
Under Dutch law, it is possible to create a very simple one-page document in which all team members assign all of their intellectual property rights that they create during the hackathon to one of the team members. You can also think of shared ownership, so two team members sharing the ownership of the intellectual property. But then again, the exception is if the law, that is the other exception, if the law does not say otherwise. As already stated, if you have a really cool job that is participating in hackathons, your employer would normally be the one that owns the intellectual property that you create. So therefore, it's always a good thing to check your employment agreement, since it is possible to deviate from this specific law. And you can also make tailor-made arrangements with your employer for this specific hackathon.
Okay. So, Jonathan, from an international law perspective, are there any legal considerations that should be taken into account when designing the solutions?
Yes, there are under international law, and just to be clear, when I talk about international law, we'll both talk about the situation where national law of various countries apply, and international law being law that applies between states, for example. So, about the first example, suppose a solution to a challenge would involve the installation of a pipeline that would run on the territory of a number of states, or a pipeline that would be installed on the seabed of an ocean, or something like that. That could trigger the applicability of the laws of a number of states. So that is something that should be taken into consideration by the participants, that all those laws should be in harmony in order to achieve the end goal. A different perspective where international law may apply is when the solution involved will touch upon an area, a physical area, such as an ocean, airspace, outer space that is regulated by international law. So, for example, if a solution would involve the use of satellite technology, then some licenses could be necessary in order to implement the suggested technology. So that is the situation in relation to international law. And I have seen on the website of the Odyssey that there are at least two challenges. I think the one on conflict prevention and the other one on sovereign nature that most probably will indeed activate or trigger aspects of international law. So I think that in any event, those two challenges should bear in mind the relevance of international law. The other aspect is, and now I'm referring to what I mentioned at the beginning about artificial intelligence, is that this being the Odyssey, it is quite probable that artificial intelligence techniques will be used. And then we enter into a relatively new realm of considerations which one could say, excuse me, are not purely legal at this moment, but may very well become legally relevant in the near future, and that is ethics of artificial intelligence. A great number of institutes worldwide have already presented guidelines on the ethical application or use of artificial intelligence. Also a group that was set up by the European Union, and I've here 4 of the ethical principles that were identified by the high-level expert group on artificial intelligence. The first one being respect for human autonomy, the second one prevention of harm, 3 principle of fairness, 4 explicability. And let me just give you an example of one of these principles, the one of fairness. Suppose your solution will involve the application of an algorithm. It is important to make sure that that algorithm would be, let's say, not biased from a human perspective, or at least as possible biased, but preferably not biased at all. And we have seen some examples where algorithms that were applied by some companies have turned out to be biased. For example, an algorithm that was used by the judiciary in the United States in order to help judges to decide whether or not a suspect should remain in jail before a trial turned out to have a certain bias for certain parts of the populations. And just to emphasize that this is not just ethics, but can also have a very much legal impact, reference can be made to Article 21, paragraph 1, or I think it's 22, paragraph 1 of GDPR, where it is mentioned that when decision-making will be based not on a human, but on a machine, on an algorithm, decision-making that will involve decisions concerning human beings, a human being should be involved in that process of decision-making. And I think that is something that Nina can further outline.
Yeah, sure. Because so I first wanted to go back to the principle of fairness, because that's actually also one of the principles which was, well, the base principles of GDPR. So there is they're in accordance with each other. And when we look at Article 22, just like Jonathan just mentioned, indeed, the GDPR prescribes that if you're making decisions with legal effect on people or similar significant effects, that if that is done in an automated way, then that person has the right of human intervenience in that, which basically means that at all stages it must be possible for a person to go back into the process and determine whether the outcome of such decision is indeed fair and was taken in accordance with all those principles, which is something which can be quite challenging, naturally, because of course it might not always, or may in future not always be possible to go back and to understand how the decision was made. But I think that is something which can be quite challenging in practice. And it's also good to realize that this is not a standalone obligation, because under the GDPR, you have the information obligation towards the natural persons. I'm sure you're all aware of all the privacy policies you've been clicking and seeing on all kinds of ads. But you should also be aware of the fact that if you're using new technologies, that you're under the obligation to provide information about that technology as well. So you would need to inform people that you're doing automated decision making, which also includes profiling, for instance. And then you would have to provide them with meaningful information about the logic and the expected consequences. Which of course, I mean, we can talk about that obligation, I think, for at least 3 hours, because what is meaningful information and how are you able to, especially if it's something which is intelligent and keeps learning and improving itself, how will you be able to provide such information? So whenever you're working on solutions like that, and I think both from a legal perspective, but also from an ethical perspective, it's really important to be aware of those obligations and to document what you're doing and how you're doing it in order to trace back the steps if need be.
Okay, so when designing the solution, your tip would be to really track that and document what you're doing, the steps you're taking, so that you'll be able to explain it later on.
Yes, definitely.
Okay. Jonathan, did you have anything to add from your side?
Well, maybe just one example in relation to ethics to demonstrate that although it is one word, there can be various perspectives on ethics. Perhaps you are familiar with the website of MIT called Moral Machine. That is a website where a number of scenarios is presented to the viewers on a choice that they can make with regard to a self-driving car that, simply put, has lost control. And in order to stop the vehicle, the viewer of the website can make a choice between let's say, sacrificing the persons inside the car by hitting a wall, for example, or hitting persons that are crossing a street. And every time, in every scenario, the configuration of the persons that cross the street and the persons that are inside a car changes. And that change can relate to gender, age, social status, and those kind of elements. And I think 2 years ago, the results, or the, let's say, interim results of the choices made by viewers of the website was presented. And perhaps not unexpectedly, it turned out that there are differences worldwide in terms of the preferences that people give to, let's say, the categories of persons that I just mentioned. So perhaps there are parts of the world where preference is given to the elderly or to younger people in terms of the sacrifice that has to be made. So coming back to the topic of today, ethics in relation to artificial intelligence, it may perhaps be very difficult to find one solution that could apply worldwide or that could be supported by people worldwide.
Okay.
Thank you.
Thank you.
Can I make one comment? I mean, I'm not an AI expert, but from the response from Nina just now, it would appear that you are adopting a retrospective approach. After the event, you go back. Mm-hmm. But in your creation of AI, is it possible for co-creation at the very beginning to see what may be the prejudices, whether on racial grounds or religious grounds, that from the point of view of co-creation at the beginning to apply principles of fairness, rather than when it happens, you go back. So that's the retrospective approach.
Yes, definitely.
I want a proactive approach from the co-creation.
Yeah, so definitely. So basically, so that touches upon the point I made earlier, because all the principles that you have to consider those from the moment you start and ongoingly. So during the entire process. So when you're in development phase, but also when you're using it, and also when you're improving it, it's something which is an ongoing process. But the difference is that you have to, the fairness principles applies in all cases, the information principle too, but that the objection that you as a natural person may have to automate decision making, that would require also at that moment for the party that's using the technology to be able to explain what is happening. So it's basically it's a two-front. So you have the obligation from the starting point, but you also have the obligation in retrospect if the information was not sufficient in the beginning.
Because the example of the judge, I would have thought that, if it's a known fact that, there have been prejudices against certain minority groups that from the beginning. Of course, if an event or factors emerge subsequently, you cannot foresee. But if you can foresee at the time when you do the co-creation, I think you should do it at that stage. Because if you go back, then it may be a question of cost also involved. And I would also like to know the question of cost when you need to update and so on.
Yeah, so basically it's an ongoing process, right? So at the start you have to take it into account, but also, and this is also I think a point you wanted to make, when implementing a solution, this is something you cannot just say, okay, this is implemented, that's it. It's an ongoing thing. You have to monitor. You have to make sure that it's still fair, transparent, etc. So it's something that you should take into account on a constant basis.
And this is also on the question of human rights,
Yeah,
yes.
And it's and also in relation to the data that you're using, because of course, if you use historic data, which, well, in most cases would probably be the case, you would also have to be aware of any bias or any prejudice that led to that creation of that historic data. And that is something I think which is challenging from all perspectives, be it if you're working from the engineering side or from an ethical side. But it's something that parties should definitely be aware of and keep thinking of actively.
I have maybe a follow-up question. When going back to the MIT ethical problem, I think there are two ways of thinking about it. One is if you use automated thinking and you imply data, then it basically becomes preventative. Therefore, you have maybe an automated system can think faster than a person. Therefore, using the data and choosing whether or not to hit a person or the wall is different than from a human perspective, because you cannot process the data that fast. If you do it as a way of thinking afterwards, then you basically do enter the perspective, I think, what you see with the black box and airplanes. When something goes wrong, there's more information. Still, the same problem is that when there is something happening, the one that has to come up with the solution does not have the information, therefore comes with a completely different set of solutions, or sometimes it crashes and people die, and sometimes people come up with a good solution and people hopefully survive. But in what way do you use the data? I mean, there's a difference between a legal perspective and an ethical perspective. Legal, people are held accountable. Ethical is basically, did you act correctly or not? Mm-hmm. And there is no legal implications for the person. So
yet
there is
yeah.
It can be.
Yeah.
The idea behind ethics is not that you help people legally accountable. Of course, you hold them accountable for something, but that's for their own mental state of mind, and not so much that they go to prison.
Yeah, but that I think maybe Jonathan can add. That's something which is they're looking into it. I think.
Yeah, I think what you're saying now is very interesting, because now let's say we are talking about the existential difference between ethics and law, and the question is whether law equals ethics or not. I think what is interesting when it comes to self-driving cars, for example, is that suppose a person would be confronted with such a choice, a person would act without thinking, perhaps, within a split second, and suppose a lawsuit would be initiated against that person. The question is whether that person would really be held liable for a certain choice, because the question can be, was it even a choice, or was it just acting? True, but suppose there wasn't really time to take a decision, and that person just acted in a certain way. The difference now with this technology, for example, with self-driving cars, is that the machines, before they will be let out in the open, will be programmed. So situations where people react, let's say, from the source of an instinct, will now be a reaction that is based on an algorithm or on a technique, and somebody has thought about that a priori. Because I spoke to someone in this field, because this is not my field. Suppose the designers would say, you know, this is a question that is too tough for us to answer. We will just leave it open. That is also a choice, leaving it open, which could also have legal implications, because then the accusation could be that the designers were negligent by leaving something open. So it could be that based on this technology, questions that in the human realm can be considered to be of an ethical nature, when it comes to artificial intelligence, will transform into a legal one.
Well, also MIT, I think, did an interesting project with teaching an artificial intelligence from the internet. That one went horribly wrong. They thought they were creating something good, and it went bad really fast, so they have to really pull the plug on that one. So if you imply that in cars, I don't think you want that. So maybe not automate their thinking and leave it open, but it's also true that there is always a human perspective, even in an automated system, because you still have the programmer, and basically they set the paradigms and the rules, and so there is still a human perspective even in algorithms.
Yeah.
And do you think those people should be held accountable for the choices that are made?
I think, in a way, yes, because if you think further enough, of course, in a way, if it's an automated car and it's still driving, technically the one that did the designing of the algorithm is technically the driver. Because you're not driving, maybe you can hit the brakes, but it's still an automated system and you set the rules, and apparently something went wrong there. Was it a specific thing was it a situation that he could think of? That's for you lawyers to figure it out.
Oh, I think that will take us a long time to figure out. Yeah.
Now something totally different. Is there a prenuptial agreement for teams? Because in the last hackathon, at the end there was a team that was a winning team and they broke up into two factions.
Oh.
So, and I think the second part of my question is, as a challenge lead, how do I protect myself against such a situation? Because all of a sudden you have winning team A and B, and with whom are you going to continue, or with both, or that's why I mentioned the prenuptial. You just think about it up front.
Yeah.
A prenup would actually be a good idea to cover this, I think. If you look at it from a legal perspective, you have the shared ownership of the intellectual property in the solution by team A and B. Therefore, both team A and B have to agree with what is happening to the intellectual property. If you want to prevent this from happening, a prenup would actually be a good solution, saying that all intellectual property will vest in one team member, be it the team lead or someone else, or in case of a trigger event, being a fight or a breakup of the team, all intellectual property will then vest in one of the team members, or the biggest faction of the team, I don't know. But there are different...
They're equal parts.
Yeah. It's free.
Maybe the challenge lead, with the track owner.
And what did you do in the end?
I gave it to a colleague.
But I mean, this is something...
We went with both teams and said, okay, we'll continue with both and we'll see, may the best win, because you continue with your solution, but it's not always a happy ending like that.
It's not always a happy ending. There is one thing we need to note, and that is that the rules of the track owner, they supersede the general terms and conditions. So if the track owner sets prenup rules, so to say, for these events, then they supersede the general terms and conditions, which state that all intellectual property vests in the entire team.
Okay, how much do you charge? Because I'm a track owner. We'll talk about that later. Yeah, thank you.
Let's talk afterwards.
Any other questions? Yeah?
Well, general principles, contract principles of frustration of contract.
Frustration.
Will that apply? I mean, maybe not in the civil law, but in the common law, there's under the general principles of contract, you have the principle of frustration, where a contract can be terminated if it's not due to the fault of the other party. So supposing team A, all of them, heaven forbid, crashed in a plane, okay? You cannot carry on. So it's a question of frustration of contract. So I was just wondering, apart from the terms that are agreed upon, will general principles of contract in a particular country apply? In the common law, there's a principle of frustration. I don't know about the civil law. I'm sure you have some equivalent.
In the civil law countries, you have this thing called, or also in the common law countries, a breach of contract. If the other team can no longer comply with the terms and conditions of the agreement, there's a breach of contract, and you can either terminate the agreement, or you can continue. But that's up to the track owners, I believe.
But then you'll first have a fight on who breached the contract, and that wouldn't bring you any further, probably. Right. So I think the lesson here is to think about the prenup beforehand, and think about what do you want to do with the IP, even if the terms are in the team stay great. but also if you get into a fight. I think that's one of the important lessons, and something that you really need to consider before entering into the hackathon.
Of course, cannot be self-induced. I mean, under the common law position, whatever your terms of contract are, they are the overriding principles of contract, and one of them is the principle of frustration, which will terminate the contract. But of course, the example that you give, I gave the example where the plane crashed, so it was not due to the fault of the whole team. But if it's self-induced, then it doesn't come within the scope of the principle of frustration. That's the common law position.
Yeah. It's like a force majeure. Yeah. Yeah. Any other questions? Yeah.
I have a question using data. What if you use data from a country that has not as strict rules as the European Union has at the moment?
That would depend on if you, as the user, would fall in scope of GDPR. So if you are any company, organization established within the European Union, or using it in the context of a European activity, so to speak, that would still trigger all the obligations, regardless of where you're getting the data.
This is actually a question we encounter quite often, that people say, okay, but I'm getting the data from India or wherever, and so GDPR doesn't apply. It does if you fall within the scope yourself. So that doesn't help you. So.
To add to this, if you receive data sets from the track owners, additional rules and conditions may apply as set by the track owners themselves as well.
So is it clear to everyone on the concept of personal data? Because I think that your experience is that this is something that the team struggle with quite a lot. Just, are we using personal data? Is that clear to everyone, or does anyone have a question on what would be considered to be personal data or what would not be considered? I think as a starting point, you should always take into account that it probably is, and if you want to make sure it isn't, go to one of the legal Jedis or someone who has knowledge about that subject, because it's really tricky to, as a starting point, think that it's not, and then find out in the course of the solution that it is. It's much harder to then implement all the things that you have to take into account.
Given this statement, what is your experience with solving this issue? Because I think the discussion about the usage of blockchain is as old as GDPR in combination. How have teams solved this in the past? Because what I'm hearing is we can't really do anything. Because everything is personal data.
No, but I think that's one of the misconceptions, that people think that if personal data is involved, that you cannot do anything, that you're blocked from doing things.
Yeah, because last year a few creative solutions. So first of all would be try to minimize the use of personal data as much as possible. But there's also a difference between what you're storing on the chain and what you're storing off chain. So I remember last year that this team only used encrypted data on the chain, basically their plan was structured in such a way that the data off-chain, so that you have the link between the two sets, but that if you would destroy the off-chain data, assuming that you can really erase that forever, then you would not be able to link the encrypted data back to an individual. And in that way you could maybe turn pseudonymized data to anonymous data. And that is something I think which is more a difficulty from an engineering perspective than from a legal perspective, because, to put it really bluntly, if you lock the door and throw away the key, that's not enough. But if you destroy the key and the lock cannot be opened, then that would be sufficient. And I think that is a engineering challenge. But that is something which we've seen, but usually using a limited amount of personal data. And there's also discussion going on within the data protection authorities, whether, for instance, hash data is to be considered personal data or not. I know that the Dutch Data Protection Authority takes the view that in principle hash data should also be considered to be personal data. But in principle, well, for every lawyer that's a challenge because in principle is not always. But there's also data protection authorities that say that hash data is not considered to be personal data. So that could also indicate that some changes are on their way. So it's a very gray area, but it's not impossible. It's just challenging. But again, it's from data protection perspective, it all comes down to accountability. So, and that's why we earlier we talked about documenting things and really thinking things through, and being really aware of why do you want it, what are you using it for, do you really need it, and then try to work around that.
We have time for one last question, I think. There's. We can take it offline, your question. Yeah.
I wonder, how do you see that the blockchain technology will revolutionize the global legal and professional industry? Because this technology is about transparency, is about trust between people, and all the big firms, and get big projects is because of the reputation and also risk management. And how do you see that this technology will bring, and it will happen in your industry? Because I personally believe in people who is doing the work.
Yes.
Not only just a big corporate's name, because that don't make much difference on that part.
Yes. Well,
Yes.
that's
Thank
obviously
you.
what we're saying as well. Well, I think, and Martijn can add to this because he's very much involved in that aspect also. I think some of our work will be standardized and might no longer be work that the lawyers do, and we see that happening. So there's in contract review, there's AI applied, and we see that more and more. But I think for some of the part of the work we do, that you still need lawyers, not only for the legal aspects, but also to apply the ethics, right? So maybe you want to add a little bit around this, because you're in our innovation team.
Thanks. No, it's a very valid point. I think you may also have picked up last week that the Atrium, which was one of the promising startups to be revolting the legal industry, and they basically announced that they were winding down. What we see is, and this is not new, and this is not, let's say, as a result thereof. I think 2 years ago, when we had the first legal deep dives at our offices in Amsterdam, we already made the distinction between production and creation. And I think that's probably where technology can come in, both the DLT, AI, but also big data. We see that we ourselves, but also our competitors, are looking into that. And we very much welcome it. It's something we do throughout our firm, but we also already have started it because we also appreciate that change cycles, since we're only human, may take a while. And I think that's also the case with all the technology we're currently working on. It takes time to adopt it and to make work. But indeed, it's about process development, so increasing transparency, and but also perhaps product and service development. So yes, the legal industry will overturn, like any other business. Digital transformation will affect everyone. So I think that's also why why participating in a hackathon like this, or in the Open Innovation Program, because it's not only the hackathon. I think that's probably good to keep in mind. But that's also what the second panel is about, is to see how that will work and how parties connect with each other, and that indeed also involves us, hopefully.
Thanks, Martijn. So I think it's time to wrap up. What we did is put some of the takeaways, or the things that we would like you to remember when preparing on the flyer. Some of the takeaways are: get the prenuptial agreement in place, read the terms and conditions, think about the open source license, think about personal data, and we'll be happy to meet all of you in April. And if you have any more questions, then you can come and see us. Thank you, everyone.